Happy Tuesday, everybody. It's time for another Real Estate Live. My name is Zeno Lancaster. I'm with the Lancaster Law Firm, located headquarters here in Asheville, North Carolina. We also have offices in Hendersonville and Canton. I like to come on every Tuesday, thereabouts, and give an opportunity for us all to discuss real estate, everything there is to do about real estate, get your feedback, get your wisdom, and also share some of my experiences with you in case it might help. Guys, real quick, we've got 3 offices, 3 other attorneys, 15 employees. We are doing closings in under 4 weeks. You tell us how fast you want it done. And of course, if you need it in 5, we can still do it then. We are here to help. So if you know anybody that would benefit from that, please tag them in the comments below. But today I'm here to talk about getting things in writing. So that might sound simple, but we're going to talk about it today because I'm seeing pretty often as things get busy, as realtors and negotiations get busy, sometimes we either forget to get things in writing or we confuse what a writing actually means, okay? On a few of my closings recently, I've had this come up. Realtors have not looked their best on these closings. So I'm always here to help you look your best. So if you have an example of a writing dispute or an agreement that you thought was in writing that wasn't, or one that you thought that you think was, but people were saying it wasn't, comment it below and we'll talk about it, okay? So one of the recent examples I had come up was the realtor said, well, I have a text message where the other side said, we'll do that. We'll fix the deck. I'm making this up, the specifics up. We'll fix the deck. You said you would fix the deck in a text message, Sally. Sally's also made up. That is not a written agreement signed by the parties to the contract. Understand, the parties to the contract are the buyer and the seller, not the listing agent and the selling agent, okay? The listing agent and the selling agent can't sign anything that obligates the parties to the contract to do anything, okay? Not without a power of attorney or some sort of authorization given, which is pretty rare. Of course, there are exceptions to most things, but in general, realtors don't have the authority to obligate a buyer and seller in an agreement they sign. So if seller is agreeing to fix the deck and buyer wants the deck fixed, and all that's happened is the listing agent texted the buyer's agent and said, sellers have agreed to fix the deck. Good, we're having a great Friday. Let's go have a beer. That is not anything, okay? That is not anything. The seller would need to sign something saying, I will fix the deck, okay, to the buyer. The buyer's remedy there, of course, as you all know, if they don't fix the deck, if they haven't signed anything, the buyers can say, well, I just don't want to buy this if they're not going to fix the deck. Or I'm okay with the deck being broken, I still want to buy it. That's pretty much their 2 options. Now, if the seller did sign something saying I'll fix the deck, then we have legal recourse. If we want that deck fixed, ultimately we can get that deck fixed. Sometimes things happen and the cost of litigation come into play, but that's a whole other video. I'm here to talk about what makes a writing. I made up a really terrible rhyme years ago to try to help realtors remember this because it's very important you remember it, and it's stop the fighting, get it in writing. What will happen is you'll get something under contract, and Fred told me a month ago when we got this under contract, he promised he would clean out the barn. He told me he'd clean out the barn, he'd have it done a week before. And he has to, Zeno. I need you to go tell him he has to. Well, does he have to? Did you get anything in writing from Fred saying he would clean out the barn? Because I got to tell you, if you didn't, he actually doesn't have to. He's actually just being nice to you at this point. Fred, if he cleans out that barn, you should go thank him and give him a big hug because he hasn't signed anything saying he'll clean out the barn. So keep that in mind when you're trying to come up with something. If it's anything important that you want, if you want that couch that's in there, you want the seller to leave the couch, you better put it in writing. And if it's me writing it, which it never is because you guys use your forms, it needs to be the red couch in the living room on the second floor with the Here's the brand. Be specific. If the Zeno, is this language good? I get that a lot. Zeno, can you read over this language we've drafted, and tell me if it's good? And most of the time, I can tell them that it's never specific enough. You need to be specific. It'll take you probably 10 seconds to be a little bit more specific, and that will reduce or eliminate. It's going to eliminate a few things. It's going to eliminate ambiguity. So if there are two couches that are similar, which couch are we talking about? It'll also help it be more enforceable. So if they do take the couch, you can say, listen, there was no confusion about what couch there was. Also, getting it in that writing actually makes them obligated to leave that couch for the buyer. What else? So make sure, again, that you're getting things in writing. I know in a busy real estate world, texts are flying, emails between agents are flying. If a buyer says, I promise I'll do this in an email, you're going to have a hard time enforcing that. You can take it to court and see if a judge agrees with you that's a signed agreement. If you have a signed written agreement, that's going to be much better, and it's going to obligate folks much more. I know, again, papers flying, you're in a hurry to get things closed, you've got 3 other showings, take the time to get something in writing. And also, guys, make sure you're working with professionals and attorneys. Obviously, I'm going to plug our office that can help you with these writings. If you have an odd writing that doesn't fit the forms that the bar and the commission have given you guys, you need that in your back pocket. You need that in your utility belt. If your attorney's not able to get that for you and get that for you quickly, what are we doing? How are they benefiting your going out and getting their contracts? So I know that I've drafted a few different agreements. One we have is a really cool one, a due diligence agreement that only extends due diligence for certain things. So due diligence ends Monday, except we also get due diligence protection for another week for lending or for the survey or whatever. If something bad happens because of lending or survey, we get to back out and still get our earnest money back. That's a form I have that your forms don't, okay? And make sure you have professionals there that can help you draft those writings that are going to keep you from fighting, okay? Post below, invite people that will benefit from this group. We really appreciate it. I think we're up to 945 or something in the group. Let's get to 1,000 by the end of the month. Wouldn't that be amazing? Again, invite people. I'm Zeno Lancaster with Lancaster Law Firm. I'm at flying_casual on Instagram, at Lancaster Law Firm on Instagrams, Lancaster Law Firm on Facebook, Zeno Lancaster on Facebook. Check us out. If you haven't worked with us before, we can do closings in under 4 weeks. Your first deal, if you haven't worked with us before, is half off for your clients. You're going to be a hero. You're going to get it closed quickly. You got it under contract because you could do it in 2 or 3 weeks. All that. So we'll see you soon. Have a great week.